And I understand that you'd like to give up your right to have a jury decide whether you're guilty or not guilty of the charge.
I think I probably have better quote-unquote connections.
Seeking to admit a number of text messages between the defendant and her ex-fiancé, Mr. Limine.
How did the Commonwealth obtain these?
The Commonwealth prepped Mr. Limine on Friday, and he provided them to the Commonwealth. They be authenticated through Mr. Limine. This is a very accurate depiction of the screenshots he took from his phone. The screenshots he took from his phone of the text.
I'm mad at Charlie from Mass Live for reporting, and then I run into the law girls later on. I'm not gonna do anything bad to the law girls because I'm mad at Charlie.
I went to half of law school.
Okay. You went to what?
Half. I did
Half
half.
of law school? That's enough. Was that enough for you?
Now I'm gonna go back.
Court now open. May we see?
Good morning, Your Honor.
Good morning.
March 18th, 2026, Courtroom 4, Lawrence, Superior Court. The Honorable Justice Jeff Karp presiding. Calling the criminal matter of Commonwealth versus Kelsey Fitzsimmons, 2025, 77 CR 311, scheduled today for a trial readiness conference. Could counsel please identify themselves for the record?
Good morning, Your Honor. James Gubitosi on behalf of the Commonwealth.
Good morning.
Good morning, Your Honor. Maureen Morgan.
Good morning, Your Honor. Timothy Bradl on behalf of the
Good morning, Your Honor. Martha Coakley on behalf of Kelsey Fitzsimmons.
Good morning. Good morning. You folks can have a seat.
And if I may, Judge, I have Ms. Healy with me,
Yeah.
so if she stays at council.
Yeah. I'm sorry, her name again?
Ms. Healy, Courtney Healy, Your Honor, our paralegal.
Okay. Yeah, that's fine.
Thank you so much.
Okay, so we're on to discuss the juror questionnaire, the draft of the juror questionnaire that I emailed you folks on Friday. I did have some preliminary questions, if you don't mind. I think these are fairly quick. So let me just ask about trial readiness. Are both sides ready to begin impanelment on Monday and then start the trial the morning after we get our 14th juror?
Yes.
Okay.
Judge, on that point, I don't want to waste a lot of the court's time. So just a suggestion is, could we do the rest of the housekeeping matters, take a quick break, and then put the questionnaire to the end? Because we may not do it. It may be a moot point.
Okay. Yeah. I actually, that's one, you're ahead of me on my agenda because I was going to, let me just skip to that item, right, what you're speaking about. So what I was going to mention to you is that I believe at the last hearing you mentioned, Mr. Bradl, the possibility of Ms. Fitzsimmons waiving her right to a jury trial.
Yes.
And what I was going to say to you, and we'll give you some time, take a break and give you some time to talk about it, but what I was going to mention to you is that I really want to, it appears to me that the law, both the statute and the rule, give me some discretion as to whether I would grant the waiver. And the only reason I would, well, let me just tell you my thinking is I would like to do everything possible to avoid having to bring 70-ish jurors in on Monday if it's going to be a waiver. So what I was going to say to you is I would need a decision by Friday, but it sounds as though maybe you'll want to talk with your client about that even today. So
Exactly.
we'll pause.
We were going to ask maybe for like 5 minutes and then.
We'll when we get to that point, you'll take as much time as you need. A couple other quick things. So the trial, we're trying to coordinate having the trial be held in courtroom 2 on the second floor, just to accommodate more audience and media members than we can fit in this courtroom, because as an example, the camera that is set up is actually, I think, either in the jury box or just too close for comfort. So our hope is that the trial will occur, whether it's bench or jury, down in the second courtroom number 2. We are still working on some logistics at our end, and you folks, especially the Commonwealth, may have some logistics that you'll need to go over with Mr. Limine. If the logistics cannot be overcome, then they can't be overcome, but at least that would be my preference, is to have a bigger courtroom than a larger courtroom is here. All right, so that's that. And also, I will need, if there's gonna be a juror questionnaire, I'm still missing Dr. Zeisel's address, which used to be in Brookline, I'm assuming, is he still in Brookline?
That's another development, Judge. We're actually not going to call Dr. Zeidel.
Okay, all right, but, so, well, we'll get to it. I'll also need, when and if we need an address for Charles DeChara, is that Commonwealth's witness or the?
No, it's, the defense put them on there, but I'm working on that actually, because,
You're working on the address?
yeah,
But the defense, it's a defense witness?
it was an independent investigation that was done by the North Andover Police, and they created a report.
Oh.
I wasn't gonna call him, he put him on the witness list, but I think I probably have better quote-unquote connections to get
Okay.
an address, so.
Yeah, just the town or the name of the business.
Understood.
Something sooner than later. All right, so those were the only two items that I missed. And by the way, I did take out Ms. Fitzsimmons as being listed as a witness. So you're going to actually see on the next version, in order to save me having to renumber, I just put number 20 intentionally omitted. There's no reason to, and I know why you did it, both sides did it, but there's no reason to put Ms. Fitzsimmons. There's going to be plenty of questions about knowledge about Ms. Fitzsimmons and the case, that her name won't be necessary on there. A couple other questions. One is on the SCRAM device. Is that some?
Yes.
Oh, hi, how are you?
Good.
Do you mind just stating your name for the record?
Yes, you're probation officer Tony Kidder.
Okay. And Officer Kidder, well, everyone, let me just think out loud for a moment. I'm concerned, or should I be concerned, that Ms. Fitzsimmons is going to be alerted during the trial to blow into a SCRAM device? Yes.
Yes, Your Honor, I did speak to my supervisor in regards to the SCRAM earlier this morning, and I was going to contact electronic monitoring to make sure that it did not go off during the time that she was in the courthouse.
Okay. All right, I don't know what I don't know. And all I know about the SCRAM device is what the probation officer at the last hearing told me about. So I just want to make sure, I'm sure that you folks are in front of this, but let's just make sure that it's not visible to jurors and she isn't seen plugging it around or going into it in the courthouse. It's still a small courthouse, right? So the probation can do something, shut it off during the court proceedings. That would be great. Actually, better yet, during the time when Ms. Fitzsimmons will be near or in this building, and again, near even coming from parking, I just don't want to take a chance that a juror is going to, potential juror is going to see her blowing into the screen.
Yes, Your Honor, I will make sure.
All right. All right, and then last thing is, so I'm already thinking about jury instructions, whether it's jury instructions or whether it's instructions to myself. And so there's two theories of assault, right? Or two ways of assault can be committed. An attempted battery, threatened battery. Is this one, the other, or both? Or what is
Both.
this? Both. Just that's all I wanted to know whether I needed to. Okay. So really, I don't have anything else. There is, Commonwealth filed a motion. So is that something that you want to do before we break? Does that make sense?
Yeah, the Commonwealth filed a motion to eliminate on Friday, I believe, or over the weekend, sorry. A motion to eliminate seeking to admit a number of text messages between the defendant and her ex-fiancé, Mr. Olayan. The text messages that we will seek to introduce span the day of the shooting, so just the day.
Look, I'm sorry, just let me interrupt, all right? So just setting it up for the record, so you're referring to paper 82, which is the Commonwealth's motion to eliminate to admit the defendant's text messages from the day of the assault. I did have some trouble reading them, but then I was given a better copy. But let me just ask, just yes or no, Mr. Bradl, is there an objection to the motion?
There is, Your Honor.
Okay, all right, so now I'll hear you. Thank you.
So the Commonwealth suggests that one thing that I think everyone can agree upon in this case is that defendant's state of mind, June 30th, 2025, is the most relevant issue before the jury. And what more insight into the defendant's state of mind in question, can we get then her text messages with Mr. Elaine? I would suggest the Commonwealth is not seeking to elicit over the weekend, over a period of time, but literally from the morning of June 30th through the afternoon, approximately sometime after 2 o'clock on June 30th. I would suggest that generally they're not particularly prejudicial, but they are relevant because they show that she is angry, upset, at times despondent, and clearly having a conflict with Mr. Elaine, and this is prior to the service of the restraining order by the Northeast Borough Police.
So your theory is they show what? Anger? What else?
They show her state of mind. And
No, I know that, but you gave me a laundry list of some state of mind you say can be gleaned from these.
From the Commonwealth perspective, she's angry at Mr. Elaine for not, Elaine has clearly, is not at the house, has separated from her for a period of time, and she is angry and is trying to get him to come back to the house and trying to reconcile. So I would suggest that that is consistent with the Commonwealth theory that this shooting happened when the defendant heard Mr. Elaine in the house.
Shooting happened.
The defendant raising her gun towards Patrick Noonan, and Patrick Noonan, in response, shooting the defendant happened at the time when Mr. Elaine was in the house.
Okay, so I'm sorry, are you saying that it's the Commonwealth's theory that Miss Fitzsimmons heard Mr. Elaine in the house and then reacted to it, or?
That's one of the Commonwealth theories, yes. And I think the testimony would be something to the effect of the defendant said, "Keep him away from me."
Like in this exchange in the bedroom or near the bedroom or whatever?
Yes.
All right. And, I'm sorry, anything else?
No, I would just suggest that it's certainly more probative than prejudicial if you just look at the text. There's nothing particularly, outrageous in the text, but it does go to show her state of mind.
So, and how would these be admitted? They'd be admitted in this format?
Yes.
Like and how did the Commonwealth obtain these?
The Commonwealth prepped Mr. Elaine on Friday, and he provided them to the Commonwealth on Friday. So they'd be authenticated through Mr. Elaine. He would explain that he received them on his phone, and that this is a very accurate depiction of the screenshots he took from his phone of the text messages he had that day.
And is this all of the text messages that they exchanged on that day, or is this a portion of them?
No, that is from that day, that is all.
All right, and the other thing that we can just flag it and we'll circle back is that I provisionally impounded, so I was out on Monday when this was filed, I believe, and I provisionally impounded the motion and the exhibit being the text messages because I saw that Mr. Bradl had requested it in an email or something. So I just want to, because it's provisional, I want to discuss how we trust all that. All right, so let me hear from Mr. Bradl.
Thank you, Judge. So evidence has to have a rational tendency to prove a proposition in the case for relevancy. And it's not a rational connection to say that because Kelsey was supposedly mad at Justin on this day, that she's going to shoot her colleague from North Andover. It's like if I'm mad at Charlie from Mass Live for reporting, and then I run into the law girls later on, I'm not going to do anything bad to the law girls because I'm mad at Charlie.
You must be the law guy. I am not on social media or any of that. So
Yeah.
don't assume I know who the folks are, but welcome. And you referred to another member of the media?
Yes, this is the law girls. They have their own blog, and it's just a rational thing. I mean, it's just this just opens the door to the Justin stuff that is completely irrelevant to whether or not she assaulted Noonan in the bedroom when it was just the two of them. There's no relevance to it, to this charge, and there is prejudice. There is unfair prejudice to show that she's in a fight with her boyfriend. Nobody wants to be judged on that, Proposition A, when Proposition B is completely different that we're here for trial on. So I just don't see the connection. Her state of mind about Justin is not her state of mind about Noonan. And there's just no possible rational tendency in terms of relevance that because she's mad at some totally different guy, that she's going to hurt her colleague and friend from work.
Well, here's the thing, is perhaps I need to do a analysis under Rule 403, but I mean, it's relevant in the sense that the Commonwealth has to prove intent. It is a general intent. And it's also relevant because I think that Ms. Fitzsimmons has put her state of mind somewhat at issue because there's information, at least that I've heard, that that if she had the gun, she didn't point it at the officer, she pointed it at herself because of her mental state. So wouldn't this be evidence, again, just not for the truth, but for just to show her mental state at the time of the incident?
So my strategy on that, and I'm happy to share it, is just that there's enough from the contents of the restraining order that without having to open the door to mini trials about who was right between her and Justin and what are they fighting about and what's going on and what are the details of that. She just received a restraining order that said, you know, as I said the other day, I won't go into it again, you know, all the things that order implied were horrible, tragic, and awful. And that prompted her to have a sad, brief moment of intense self-harm. And thankfully it didn't happen.
Let me say this. I read these text messages and I arguably thought that they helped you, frankly, because
Sure.
I know that the Commonwealth sees anger in them. And yeah, I think it could show that, but
I agree.
But they also arguably show it's what they don't discuss. I guess I'll just leave it at that.
And that's my point, Judge, is that it's opening doors. It's like opening more doors about this when we're not intending on opening that door. And, you know, I don't want to have that thing where, oh, well, this helps us, but then that might hurt us, and then this might help us, and then we're having a mini trial about Justin versus Kelsey.
But Mr. Bradl, with all due respect, you folks put Mr. Ayala front and center. Maybe you've changed your mind about that. It sounds like maybe in the last hearing you have,
Yeah.
which you have a right to do that, obviously, but he's been pretty prominent, and their relationship has been pretty prominent from the defense's perspective, from what I've heard, all right, and seen.
So if I can speak to that, I don't need to talk about it.
Oh, go ahead.
Sorry. So, Judge, we have to play both sides of that street because the government is pushing that. The government wanted to put, you saw that prior motion limited where they had these 4 things that are like, you know, this is judgment day for Kelsey's entire life. You know, the government wanted to open this case up to Justin and Kelsey and what happened in Maine and all this other stuff, you know, and I think the government's backed off of that. But the government started that fight, and I have to match it. I have to be ready if, out of an abundance of caution, if the government was going to go down that road, I got to be ready. So that's, you know, the Justin stuff has to be vetted, and I have to be ready if he's called and if he is a witness. You know, I have to be ready on both sides. My preference is that we have an economic trial here where, you know, the issue is Kelsey gets this restraining order full of horrible nightmares. She acts accordingly on it. The government puts their case in, we put our case in, and the fact finder decides. You know?
So, but don't these text messages help your client show that? Because I'm not, again, listen, the Commonwealth, you know your case, both sides. I only know what little I know from the file.
Sure.
But when I read these, yes, maybe there is anger, maybe you could say that, but there's also an absence of any concern for her mental well-being by Mr. A.L. Any comments made by Ms. Fitzsimmons that would lead one to believe that she was suffering emotionally at this time. So I guess that's part of the analysis of when I'm doing the 403 analysis is on the prejudice to the defendant. I'm not sure that I see a lot, but I can tell you this, is that there is one passage in here that I thought I saw that where he said something about her allegedly hitting him or something, and
It's on the first page, Your Honor. It's the fourth bubble on the right.
So I give you a proffer on that, and so I appreciate what you're saying, Judge, about on its face, though, the general gist of those text messages would help in the sense of the distraught mindset. However, if that's where it sits, I can live with that in terms of but we'll talk about the hitting thing. But I'm looking at this like, I feel like the government's going to try to say that this opens more doors, and I don't want to go down this road of like going down, Justin versus Kelsey and everything in Kelsey's past going back to two other ex-boyfriends. Like, that's where I want to guard against.
Commonwealth said 2 hearings ago, this is a simple case. You said at last hearing, and it will be a simple case, but it's still simple in the sense of what happened in the bedroom.
Right.
And it seems to me that what Ms. Fitzsimmons was thinking at the time and is absolutely relevant, and then her state of mind in the hours leading up to it would be relevant too. So, and again, let me say this. I'm making an observation about what I say that they could arguably help defense or hurt the Commonwealth, but that's only because, again, when I'm weighing the potential prejudice to the defendant and the probative value, that's all I'm really getting at under 403. So,
Judge, if I could just invite the court to just focus on that one bubble about the hitting in terms of the 403. And that's really all I'd be concerned about.
So
There's more to the story, of course.
All right, so let me just, in Commonwealth, what would you say if that was redacted? So that bubble and just...
I just think the first sentence of that would be fine to redact, but I do think that the second sentence is not about what you need anymore. We need to be the best parents possible, and I cannot do that in the house at this time. I think that's...
So, Mr. Bradl, I don't know if you've heard that. So the Commonwealth is suggesting that... All right, so let me just back up. So my ruling is that the probative value of these, generally speaking, of the proposed exhibit outweighs almost any potential prejudice to the defendant, except that the devil is in the details as to some of the content, and that one of those items being this particular passage where Mr. A. Ellen is alleging that Ms. Fitzsimmons struck him in the face, even though she denies it right there in the spot. So the Commonwealth is suggesting we simply just redact the first 2 sentences of the bubble of Mr. Elaine text about that.
Should that be agreeable to the defense? Thank you.
Okay. And so that would, and the rest of that would come in starting with, it is not about what you need anymore?
Yes, sir.
Okay. And if you folks remind me at the time that I can tell the jury that it's common that things are redacted or struck from items just in case it's somehow visible that, in other words, if the jurors can glean that something's been removed, I'm happy at the request of either side to tell them why, which is basically out of the rule that it wasn't.
And Judge, also while we're on these, I would waive the request for...
Okay, waive the request for impoundment.
Correct.
So let's talk about impoundment. What's the Commonwealth? I'm just concerned about jurors, just knowing, but I don't know.
Your Honor, this is, I do not see a good faith reason for the Commonwealth to ask for this to be impounded, given the nature of what is in the public already.
Okay, all right, so both sides say it shouldn't be impounded, so I'm gonna vacate, and I'll do this, Mr. Wayne, in an endorsement, but I'll vacate the provisional impoundment of that. What I'd like to do is this Commonwealth, so I have 2 versions, one's a vertical, and one's a horizontal. Is that right? Is that the way to explain it?
Yes,
So
I think the first version was too small really to be
Yeah.
seen, so.
So can we just give this back to you, and then you can shred it, and this will be this landscape. right? That's the landscape, okay.
And that's a good one.
The landscape will be the official exhibit. It will, and it can be docketed in the normal course, public, strike that, docketed to the public docket. All right, and I'll have to also endorse, I will endorse it that I'm allowing it subject to that revision, so just, all right. And so, do you folks want to take a break for a few moments? Okay, all right, we'll do that. Just let, Mr. Ruiz know, and you folks are.
All rise, please.
Thank you very much. We can go back now.
Yeah, if I want to run. I will leave.
Okay.
Of course, this is a brief recess. All right, we're back in session, you may see.
Your Honor, we're back on record on the matter of Commonwealth versus Kelsey Fitzsimmons. All counsel and the defendant are present.
Okay. Bradl?
Thank you, Your Honor. We filed two things. We filed a waiver of the right to a jury trial, and Attorney Colloquy and Ms. Fitzsimmons are prepared to engage in a colloquy with you on there.
Okay.
And then the second thing we did file was a supplemental witness list that I explained to my brother a little bit. Some additional names. I would say most of it is probably abundance of caution stuff that probably they won't be called. There's one name on there that did warrant some explanation from the Commonwealth, which I gave them, and I don't expect it to really add much to the trial.
All right, so let's table that, but I do want to, if the Commonwealth wants to be heard on these additional witnesses, absolutely, no.
No, I just, if I may put something on the record.
Sure.
As far as the jury waiver goes.
Well, before you do that, I was
What?
going to ask, all right, so we have a waiver. I was going to ask whether the Commonwealth takes a position, so.
My only position, while I have no reservation with your ability to be fair and impartial in this case. In an abundance of caution, I wanted to create a record. At some point, I don't think it was last hearing or one of the press conferences the defense gave outside, a person asked about you, and Attorney Bradl told them and the world, I guess, that you and he worked together in the DA's office some time ago. And so I think there's a perception out there for whatever it is that the defendant had put out there. Like I said, I have no reservations as your ability to be fair and impartial, but I think I needed to create a record about that.
No, that's a very good point. So, I don't, let me say this. I said before when I was joking with our media representatives, I don't pay attention to social media. I'm not on social media purposely. I don't read or listen to or watch it, whatever, media accounts of what happens in cases that I preside over or that I potentially be involved in. So I know nothing about that, but I think it does make sense for me to say a couple things related to that because it strikes me that I did discuss those things with you folks, but I did it at side. Right, so I'll just state for the record that Mr. Bradl and I, so we worked together, well, Mr. Bradl and I were in the same starting class. We were affiliated in January of '95. I have Mr. Bradl, I have a picture of all of us, including Mr. Hagan, Judge Hagan, who got me back here. So Mr. Bradl and I were in that starting class together. My memory is that I signed ultimately after the class. I think we met for a couple of weeks for the training class. I was assigned to Rock Street District Court, Bradl District Court, and so that was nice. I left the DA's office in 2001, and at that time I was the chief of the which was the Superior Court unit. So Mr. Bradl, you can correct me, I don't think that we ever worked together in the sense of worked in the same courthouse, worked on the same trial team. I'm not sure that you and I ever even had a beer together back then.
I don't recall. I don't recall one, and I think that I put you kind of in the same boat as Judge Deacon down in Middlesex, where we always
had a respectful cordiality at work, but, nothing past that. I appeared in front of Judge Deacon and, it's never been a problem. And I left the office in 06, so I was there for 5 more years after you. And I haven't seen you in probably over a decade, and I think the comment that counsel is referring to, I recall it as a sort of a generic comment that I thought your rulings were fair and that we appreciated your rulings because I had known you a long time, something to that effect.
Yeah, I don't think that Mr. Gubitosing is objecting. You just want to make sure that this trial, I've always strived that all of proceedings, whether it's this case or other cases, are treated that there's a level of transparency. And I think Mr. Gubitosing's point is well taken. So I think I've described on the record what the nature of our relationship was. I'm not, again, I can't say that we weren't friendly, but it seemed like I was maybe you're the pool of people that you more gravitated to were from the Georgia District Court and I was in the Roxbury District Court. But I'll also say this, that for complete transparency, I believe I know I had a murder trial years ago with Mr. Gubitosing. I found Archangel Morales, I don't know if you remember that. And I found working against you was a really good prosecutor and really clear, and I respected you, and I continued to. That's what I was trying to at sidebar.
Maybe I'm not that.
I probably spent
No, I was going to say maybe I'm not that memorable because we did 3 murders together.
You did?
Yes.
Who else?
I can't remember the names. One was with Ms. Ronan in front of Judge Lowy in Salem.
Oh, wait. All right. So I'm not.
And there was another one here. I can't remember the judge. Right, right.
I wasn't counting the ones where you were second seating another. You were like second seating a more junior attorney, but I do remember one in which the 2 of the prosecutors beat me up pretty good. It was here in this courtroom.
I remember that also.
I had made a mistake and opened the door to something, and Mr. Gubitosing's fault because all of a sudden that sidebar. I hadn't said 2 words during the trial, but raised the issue. But in any event, listen, I respect both of you folks. I said on the record, I don't go just hopefully, I don't believe professionally. I think that you may have been the chief of a unit that in Middlesex at the same time that I was the chief of the domestic violence unit. I think we may have traveled in the same circle of both decades ago, but I don't think that we're here before we out here like this against each other. Again, I respect you as much as I know, and then I think that's full disclosure. I'll also just say that as for Dr. Zeisel, you said Dr. Zeisel not going to be correct. Okay. So because I think I already mentioned that he was somebody that someone often when I was in class. But all right. So is that sufficient? All right. And the bottom line is, I am confident that I can be fair and impartial. I would not accept the waiver, frankly, if I thought that there was some risk that some favoritism would potentially come into play, or if I thought that I couldn't divorce myself from information that may not be admitted at the trial. Okay, so I'm very good at compartmentalizing. I only consider it after. All right, and then we'll talk about mechanics and all that afterwards. Let's go through the colloquy. I'd like to, before we have the colloquy, can I see counsel and Ms. Fitzsimmons sidebar thing? Attorney Colloquy, is Ms. Fitzsimmons ready to proceed with the colloquy of the waiver?
Yes, she is, Your Honor.
Why doesn't she take the witness stand? And we can pull a chair over for you, Ms. Attorney Colloquy, if you'd like.
I can stand.
Please.
Ms. Fitzsimmons, could you raise your right hand? Do solemnly swear to make true answers to such questions put to you by the court or upon its directions to help you God?
Yes.
Okay. Good afternoon. You can have a seat.
Good afternoon, Your Honor.
You can put yourself right up to that mic. So as you know, I'm Jeff Karp, and I'm a judge here at the Superior Court. And I understand that you'd like to give up your right to have a jury decide whether you're guilty or not guilty of the charge. And I need to just ask you some questions to make sure that you understand the right that you're giving up and you're doing it voluntarily, okay? And that you know what the consequences. Now, so I'm going to have a lot of questions for you. If at any time you don't understand something that I say to you, it's perfectly fine to interrupt me and tell me I don't understand. If at any time you'd like to take a break and speak with Attorney Colloquy, we can give you that opportunity. We're in no rush here. It's very important that you understand all that I tell you. And yeah, okay? All right, so first thing I'd like to do is, where's the indictment, Mr. Boyne? I just grabbed that. So you understand that you're charged in a single indictment with the crime of assault by means of a dangerous weapon. Do you understand that?
Yes, Your Honor.
Okay. And do you understand that have you discussed with your attorneys what the Commonwealth needs to prove at the trial for that charge?
Yes, Your Honor.
Okay, and you feel as though you understand what they've told you about that?
Yes, Your Honor.
And do you understand that that charge, assault by means of a dangerous weapon, carries up to 5 years in state prison if you're convicted?
Yes.
Okay. And, and Attorney Colloquy, either you or Attorney Bradl have gone over the elements of the charge with Ms. Fitzsimmons?
Yes, Your Honor, we have.
Okay. All right, so I need to just ask you some background questions to get some background information. Some of this I already know, but I still need to, I need to ask you formally. So if you could state your full name.
Kelsey Erin Fitzsimmons.
And how old are you?
I'm 29.
What is just your month and year of birth?
11/18. November 18.
And where were you born?
Concord, Mass.
How far did you go in school?
I got my bachelor's degree and I went to half of law school.
Okay. You went to what?
Half. I did
Half
half.
of law school? That's enough. Was that enough for you?
No, I'm gonna go back.
You're thinking about going back?
I am.
And you said you got a bachelor's degree in what?
In criminal justice.
Criminal justice, and where from?
Where am I from?
No, where did you get?
Oh, I'm sorry. I'm nervous. I'm sorry. Fisher College in Boston.
Okay, all right, and totally understandable that you're nervous. All right, and again, some of this I know, but I have to ask, what are you? You can't be presently working, right? You're not working now.
No, you're
All right, and your last job was with?
patrol officer with the North Andover Police Department.
Okay, and how long were you there, roughly?
About a year and a half, if you count the academy.
Okay, so you went to the police academy, and
Yes.
and what else? And just normal job duties as a patrol officer in North Andover.
Respond to 911 calls, emergencies, medical emergencies, calls for service in the town.
Okay, all right. And did you take any prescription medications, over-the-counter medications, or drugs in the last 24 hours?
Yes, I have.
Okay, and what have you taken in the last 24 hours?
In the last 24 hours, I've taken fluoxetine,
Okay,
hydroxine,
okay,
and lorazepam.
all right. And do any of those medications, or have any of those medications affected your ability to understand the proceedings today here?
No, Your Honor.
All right. And did you consume any alcohol in the last 24 hours?
No, Your Honor.
And have you ever been treated for any mental health?
Yeah.
Okay. And do you feel as though that you're suffering from any mental health condition today? In other words, that like right now as we're going through this, that you're feeling some effect of any mental health condition?
No.
And do you feel as though your mind is clear today?
Yes, Your Honor.
And have you understood all that I've discussed in open court with the attorneys about, up to this point, about the even like the motion to admit the text messages, have you understood all of that?
Yes, Your Honor.
Okay. And so I'm just going to go over your constitutional rights. So you have a constitutional right to one trial of the charge. And you have the right to choose whether to have a trial before a jury or a judge. At a jury trial, the jury decides whether you are guilty or not guilty of the charge. And the judge's job during a jury trial is to rule on legal issues that arise during the trial, to instruct the jury on the law of the case, in other words, what the Commonwealth has to prove, and to impose a sentence if the jury were to find you guilty. So that would be the judge's job during a jury trial. But the jury would decide whether or not the Commonwealth proved that you are guilty beyond a reasonable doubt. All right? You understand that?
Yes, Your Honor.
And at a jury trial, you have the right to a trial here with 12 jurors. These are people selected from the community. You'd have the right to participate in selecting jurors. And you could not be found guilty at the jury trial unless the Commonwealth convinces all 12 of those jurors that you are guilty beyond a reasonable doubt. So do you understand all of your rights and how a jury trial works?
Yes, Your Honor.
All right. And also, you could choose to have a trial by a judge instead of jury. And in such case, the judge cannot find you guilty unless the Commonwealth convinces the judge that you are guilty of the charge beyond a reasonable doubt. Do you understand your right to a judge trial?
Yes, Your Honor.
Do you understand that by waiving your right to a jury trial, the judge will be me? I will be deciding whether the Commonwealth has proven the charges. Do you understand that?
Yes, Your Honor.
Okay. And you understand that by waiving or giving up your right to a trial by a jury, that I just already told you. So do you generally understand the difference between a judge trial and a jury trial?
I do.
Okay. And do you have any questions at all about the difference between those two types of trial?
I do not.
Now, just hand you this. And I'm showing you a form called a defendant's waiver of jury trial and consent to trial by a judge. Did you read that form?
I did.
Did you discuss it with counsel or the attorneys?
I did.
All right. And did you sign that form?
I did sign it.
And do you understand that the form says in writing what you and I have been talking about thus far about giving up your constitutional right to a trial by a jury?
Yes.
Okay. Did you sign that form voluntarily?
Yes, I did.
And by signing the form, are you saying in writing that you know about and understand your right to a jury trial, which is explained on the form, and that you voluntarily give up that right?
Yes.
All right. And you now willingly and voluntarily waive your right to have a jury decide your case instead to choose. You think that I have never done this before. Maybe I'm the one that's nervous.
I'm not ready to go. Okay.
Let me start over again. Do you now willingly and voluntarily waive your right to have a jury decide your case and instead choose to have a judge, that being me, decide if you're guilty or not?
Yes.
Okay. And do you understand that your waiver of your right to have a jury decide your case is final, and you cannot change your mind and ever ask for a jury trial again in this matter? Do you understand that?
Yes.
Has anyone threatened you or forced you in any way to waive your right to a jury trial?
No.
Has anyone promised you anything in return for your decision to waive your right to have a jury decide the case?
No.
Have you had enough time to fully discuss your right to a jury trial and the difference between a jury trial and a judge trial with your attorneys?
Yes.
Do you feel as though your attorneys have acted in your best interest and that they have fully and adequately explained your right to a jury trial and the difference between the two types of trials?
Yes, Your Honor.
Have you been confused by anything I've said thus far during this colloquy?
No.
So as I understand it, then you're waiving your right to have a jury decide your case, and you're choosing to have me, a judge, decide whether or not you're guilty because you want to and because you believe it's in your best interest to do so. Is that correct?
Yes, Your Honor.
And the defense, any additional questions that pose?
No, thank you.
None? Okay. All right. And does the defense or the Commonwealth know of any reason I should not accept the waiver?
No, Your Honor.
Okay, all right, you may step down. Thank you very much.
Thank you, Your Honor.
All right, I'm gonna make the following findings. Yeah, Mr. Rowan, you take that. Thank you. So I'll make the following findings. I find that the defendant, while she is presently or has taken medication, prescription medication in the last 24 hours, I find that that medication has not affected her ability to understand and participate fully today. I also find that although the defendant, Ms. Fitzsimmons, has reported that, or at least, I don't know if she reported it, but I do know that at least in the past, she suffered from mental health conditions and that perhaps some of that medication is related to that. I do find that any mental health condition that Ms. Fitzsimmons may have had or has not affected her ability to understand and participate fully in the proceedings here today. I further find that Ms. Fitzsimmons understands the nature of the charge against her and the consequences of waiving her right to a jury trial. I find that the decision to, I find that Ms. Fitzsimmons' decision to waive her right to a jury trial is made with the advice of competent counsel. And finally, I find that the defendant's waiver of her right to a jury trial has been made knowingly, willingly, intelligently, and voluntarily, and with the full knowledge and understanding of its consequences. And accordingly, I accept Ms. Fitzsimmons' waiver of her right to a jury trial. All right. With that in mind, so will anything you folks want to go over, but I anticipate we'll just start on Monday morning. Are you prepared to? Because maybe you're not, but given that I had said that.
Sure, I hope to be. I mean, that wasn't the plan for all our witnesses, but we'll reach out today and make sure,
Okay.
or ensure everybody that we can have is available Monday.
Okay. All right. And so let me say this. I realize that from both sides' perspective that, you know, trying a case, whether it's jury or not, is like trying. It's difficult herding all your witnesses together. I usually try to make a joke about it's like herding fish or something, but Mr. Kubatosi's heard that a few hundred times. So, but in all seriousness, we will, Ms. Rowan, we're going to go full days.
Yeah.
And to the extent that you folks, you run out of witnesses on a day, that's just life, that's fine. Do you expect now with this new, let me ask, with the new kind of schedule where the trial is, the actual evidence and trial is going to start earlier, do you expect any witness availability issues?
Well, everybody was free for the week, so no, I mean, I don't anticipate whether somebody is available Monday in particular.
Okay.
We'll find out. But
All right. So it is my anticipation that however we proceed, that the trial will be over by Friday. Is that a good, fair schedule or fair belief that I hold, I guess?
yes, so
Okay. Okay, so we'll just start up on Monday morning, all right? I'm gonna see you folks. Yeah.
Sorry, I just wanted to point up something for you that you were talking earlier about jury instructions and instructions that you would take into account yourself. And there's one slight, maybe a curveball. There's a Code of Massachusetts Regulations. And I just want to give you the citation. It's 555 CMR 6.05 parentheses 3 close parentheses.
All right. So let me say this. I don't know exactly what you're referring to, but maybe it makes sense for me to just explain. So what I will ask is that you folks submit. They can be in the form of jury instructions, but just the instructions that I will use when I deliver as to the law, assault by means of a dangerous weapon. So whatever it is that you're referring to, Mr. Bradl, you should just put in that document again, whether it's however you want to type it, fine, but.
It's from the post-commission regulations, Judge, and it's just a it's a CMR that states that an officer is not permitted to use deadly force to someone who is a danger to themselves. And that's really the central issue.
Yeah, right, but again, without having it in front of me, what does that have to do with whether the Commonwealth will be able to prove that the allegation is that Ms. Fitzsimmons committed the assault by means of a dangerous weapon, so I'm not following.
I think it has sort of a general import where if the court has a reasonable doubt as to whether or not Ms. Fitzsimmons was engaging in conduct that was harmful only to herself, it does not, by law, excuse the Officer Noonan shooting her.
Frankly, I don't understand, but so let me just hold on one second, Mr. Brady. What I expect is that perhaps at the end of the evidence and even before closings, we'll have a charge conference. We'll treat it just like we would in a jury trial, and you folks can make your pitch on the law, but I will want some submissions on the law that I should be, again, as it relates to the charge and the elements and things of that nature. If there's some defense that you're asserting related to that, you can, perhaps that would be a mechanism for raising that. All right, but right now, I don't understand it, and I'm not sure that I need to at this point. All right, anything else?
Your Honor, do you start at 9 a.m.?
Yes, I'd like to. We do our best to start at 9. Mr. Wayne and I are always ready, but
I know Mr. Wayne was up early. But
Mr. Wayne and I seem to be the only ones that are ready at 9. But yeah.
And just folks, 9 to 4 is a full day for the court. I'm just
Right.
Okay. Thank you.
It is. And like I say, if you folks can disclose to one another what witnesses you think you're going to be calling on a given day, and that would be.
And with your permission, I think we should be able to pre-mark a number of exhibits. Okay.
So you'll work that out with Mr. Wayne, that would be great. Also, if we need to take a defense witness out of order, I certainly would hear the Commonwealth if there's opposition to that. But even for a jury trial, I typically would allow that. So, again, if it's a scheduling related matter, not a strategy related decision, but if there's some scheduling conflict that will help to proceed. All right. So we will see you folks on Monday morning. Thank you.
Thank you, Your Honor.
Please.
I'm going to,
Please step up, folks.
nicely articulated. Okay. Go down there. So,
This is just
Oh, okay. Yep. Tell me to down there.
Yeah.
Only,
Eric,